So today we're going to start with Griffin versus School Board of Prince Edward County, and we're going to start here for kind of two reasons. Um, First, there is a big gap between the last case we covered, Cooper v. Aaron, or not, yeah, Cooper v. Aaron, and this case. And that time gap, some very notable things take place. Um, in 1957, Congress passes or sets up a commission to study and investigate acts of discrimination in civil rights. In 1960, Congress moves forward with strengthening existing laws that already took place that made violation of certain criminal actions or violation of certain discrimination laws criminal. But really the biggest step and the largest signal to the court and also to the nation that Congress was no longer playing around was the passage of the Civil Rights Act of 1964, in which primarily Title II bans discrimination in public accommodations based upon the Commerce Clause, which, in large part completely changes the jurisprudence of the civil rights cases and also kind of follows the civil rights cases in the foreshadowing of that perhaps in the civil rights cases they argued that you could use the Interstate Commerce Clause to actually reach into the states. And so the court is kind of sitting back and watching all of this action take place with Congress. And really with the Civil Rights Act of 1964, they see they have allies. It isn't just the president who is allied with them, or the president, even as time changes, who's allied with them, but they have support of Congress as well. And once those two mechanisms are sort of in place, they feel much more comfortable acting. Some other parts of the Civil Rights Act of 64 that we should talk about that we may not get to like in depth in this class, but are still important to note. Title IV provided for the helping implement Brown. So Congress was explicit in Title IV of the Civil Rights Act, helped desegregate and helped provided tools for desegregation. Title VI bars discrimination in education and would cut off and had the ability to cut off federal funds to any school which continued to practice segregation laws. And so schools ultimately had the choice of to desegregate or lose federal funding. And federal funding is a big boon to schools. And so the choice there really wasn't much of a choice. If schools were still going to operate, they had to comply with Title VI. And then Title VII bans discrimination in terms of employment and establishes the EEOC, or Equal Employment Opportunity Commission. So all of these things really signal to the court that we're on board, Congress is on board, and they can start moving ahead. So there were a few cases which came up during the time period really between Brown and Griffin. And I'm kind of jumping some significant cases that took place in there. To give you an idea of what some schools, school boards, some states, some localities have done. Perhaps the most notable, and this was ultimately the decision that the Supreme Court struck down, or an action the Supreme Court struck down, a school district abolished public schools, just flat out abolished public schools. So if you're going to force us to desegregate, there are no more public schools. We're not providing that service, but we will provide individuals with vouchers so that they can go to private schools. Now, it turned out, not at all shockingly, that none of the private schools would admit African-American students. And so the Supreme Court stepped in that case and struck down that action. But the series of cases up to this point had been very focused. And this is sort of, Griffin is the Supreme Court's shout to all of those states that were resisting desegregation efforts, that time had really come to stop. And it was time to move forward with desegregation in some meaningful fashion. The reason why the court chooses this case primarily for the vehicle of signaling that is because the factual setup of this case is just so absolutely preposterous that it provided a nice springboard for the Supreme Court to actually chastise the South, more or less. So the original complaint that starts this case was filed in 1951. So it was filed before Brown v. Board of Education. The initial complaint was by African American children that were arguing that they were being denied their constitutional rights by not being allowed to register at a white school. Now, this area in which this was taking place was in Virginia, and it's just outside of D.C. So it's not like we're talking about deep South. This isn't Georgia. This isn't Alabama. This isn't Arkansas of the 1950s. This is Virginia of the 1950s, directly outside of D.C., directly outside the seat of government. So the federal district court in Virginia was supposed to oversee this case. And they did in large part. But based upon Brown 2, they recognized that the efforts of Prince Edward County's schools to desegregate was being met with, quote, resistance. That resistance that is a little bit downplayed. The state legislature of Virginia had taken a number of steps to ensure that desegregation would not take place ever. They passed laws closing schools where there were African American children and white children attending at the same time. So the state legislature of Virginia was very much an impediment towards desegregation efforts. The actions that the state legislature took were eventually invalidated, but the district court then further delayed desegregation efforts. Finally, and thankfully, a different district court sort of takes up this case and started to enforce desegregation efforts. So the local school board, particularly in this case, the school board of Prince Edward County, began to take legal steps to invalidate the orders of the district court judge. And those invalidations were held up by the Federal Court of Appeals of the Fourth Circuit, which oversees Virginia. And thus, that is the mechanism by which this case comes to the United States Supreme Court. So the United States Supreme Court is weighing in on an issue that started, at least legally started, in 1951. And here we are 13 years later, and here we are really 11 years after Brown. So the court has seen what's happened, has watched what's happened nationwide, particularly in the South, though, as I said, this case isn't in the South, really, it's in Virginia. And the Supreme Court, seeing the support of the other branches of government, begins to really flex its muscles. So the issues in this case, the issue primarily, were the actions taken on behalf of the federal district court in line with the decision in Brown 2, which allowed for all deliberate speed in terms of desegregating. The Supreme Court in this case could not be more imperative in saying no, that the district court and the school board and the state of Virginia have run afoul of our decision in Brown 1 and Brown 2. The Supreme Court says that we hold that issues here imperatively call for decision now. This case has been delayed since 1951 by resistance at the state and county level and by legislation and by lawsuits. The original plaintiffs in this case have no doubtlessly all passed high school age. There has been entirely too much deliberation and not enough speed in enforcing the constitutional rights which we held in Brown have been denied Prince Edward County Negro children. So the Supreme Court decisively says, no, you've wasted enough time. When we said all deliberate speed, we really didn't mean 11 years. And the fact that it's taken 11 years in this case itself has taken 13 years is absurd. The Supreme Court held that although states and local governments still have a wide degree of discretion to run their public schools, they cannot take unconstitutional actions, and the actions taken in the arena of public education that deny African Americans equal access are a violation of their Equal Protection Clause. And so the court presses hard in these cases and says, in essence, that you have to move towards desegregating. You have to move towards desegregation quickly. Um, and there needs to be no more delay. Um, and the court sort of signals that if there continues to be delay in this area, then we might move in a different direction. And they don't really signal what that direction is. The next case makes it very clear what that direction is. But this is the really differentiation that I want you to get from this this is really and truly the last desegregation case that the Supreme Court takes up. And what I mean by that is the goal of the Supreme Court in this case was to desegregate public schools. They really changed their tone in the next case, in the cases that follow, and they move towards what we can commonly understand as integration. So they move away from desegregation and move towards integration. Now, desegregation is the removing of legal mechanisms that segregate African American students from white students. So you tear down the legal mechanisms. That's desegregation. So that schools could be equal, could include African American students and white students. But integration is a very different thing. Integration requires that schools have African American students and white students together in the same school system. One is removing legal impediments. Other is mandating that African American children are in the same schools as white children. And that is a much more activist bent, a much more solution-based movement by the court. And that's where the court moves to in the next case, focusing less on desegregation efforts and focusing much more completely on integration efforts.